Chapter 4, Tort Law. Tort law is an often misunderstood and maligned area of law. Especially since the McDonald's hot coffee lawsuit in the 1990s, there have been frequent calls for tort reform. Attorneys who practice torts are sometimes referred to as ambulance chasers. All a tort is some sort of non-contractual civil wrong between parties that has caused an injury or other harm between them. The four categories of torts are intentional torts, negligence, strict liability torts, and product liability torts. In this chapter, we'll discuss each of these categories as well as how the courts determine damages. Let us begin with intentional torts. Intentional torts. Most of the time when we're thinking about torts, we think of negligence, where a person causes a harm on accident. Intentional torts are those torts done on purpose. This is important because for a person to be liable for an intentional tort, the plaintiff must be able to prove, by a preponderance of the evidence, that that person intended to do the bad act. Remember, we're talking here about civil law, which means we're talking about liability or responsibility instead of guilt. And we're talking about this lower burden of proof, preponderance of the evidence, as opposed to beyond a reasonable doubt, which is what is needed in a criminal case. This distinction is important because many intentional torts are also crimes. The difference, as we'll see when we discuss criminal law, is who the plaintiff is. In a crime, the plaintiff is the government, whereas in a civil tort, the plaintiff is the actual victim. As you're leaving the bar, a person punches you, breaking your jaw. This is the crime of battery. The person is charged with a crime by the local prosecutor and perhaps serves some jail time. However, you, the victim, are left with a broken jaw, the doctor's bills associated with it, and the lost work, not to mention your pain and suffering. The defendant going to jail solves none of these problems for you. So, you sue them for the intentional tort of battery, and in your complaint's prayer for relief, you request compensation to make you whole and get you back into the position you were before the battery. The following are some common intentional torts. Your state laws will certainly vary. Assault. Assault is putting someone in reasonable fear of imminent harm. Notice that there's no requirement here that the victim is actually touched. Assault is simply a threat. There are two key elements required for a successful assault lawsuit. The first is reasonable fear. Not only must you prove by preponderance of the evidence that you were personally in fear, but also that your fear was reasonable. In other words, most people would agree that it makes sense that you felt fearful. If a child threatens to punch you, that is not assault, because no reasonable adult is going to be fearful of a child. People joke about this all the time when we make up scenarios, like how many third graders would take to beat us up. Personally, I think it would take about 300 before I became too exhausted and was overtaken. Actually sounds like a lot of fun. The second element is that the harm must be imminent. It must be happening very soon. If a person calls you on the phone from 2 states away and threatens you, that is not assault. They cannot make good on that threat anytime soon. Battery. Battery is the intentional and non-consensual touching of another person. This touch can be with the person's body or with an object. If a person punches you, that's battery. If a person throws a rock at you and misses, that's assault. If a person throws a rock at you and misses without you knowing he threw it, that's nothing at all, since you were never put in reasonable fear. If a person throws a rock at you and hits you, that's a battery. We frequently hear the terms assault and battery used together or interchangeably. The reason for this is, besides simple ignorance, because a person often threatens someone with harm, assault, and then makes good on their threat, battery. No actual injury is required for battery. Bodily autonomy is sacred on its own, and a violation of that is sufficient grounds for a battery lawsuit. However, any injury suffered will certainly increase the amount recovered in a lawsuit. Battery is an intentional tort. So like all intentional torts, you must prove that it was done intentionally. If I bump into you, that isn't battery. I didn't intend to touch you. It isn't the damage that must be intentional. It is the contact. False imprisonment. False imprisonment is the act of confining someone against their will by force, threat of force, or barriers. You are denying someone their freedom of movement. If I hold you down, prevent you from leaving, that is false imprisonment. If I ball up my fist and tell you that I'm going to punch you if you leave, that is false imprisonment. If I lock you in a room that is false imprisonment. If I lock you in your room by accident, that is not false imprisonment because an intentional tort requires that I intend to do the bad act. Conversion. Conversion is simply the intentional tort of theft. If you intend to take something belonging to another person for your own benefit, denying them their own property, you have committed the intentional tort of conversion. Consider the example at the beginning of this section of the broken jaw. That person being criminally charged doesn't help the victim. The same applies here. If a person breaks into your home, steals your television, and sells it to someone, having that person charged with theft doesn't help you with the financial loss of having to get a new television. You would need to sue them for the cost of a replacement. Conversion doesn't only apply to theft. Imagine a nasty breakup. Your boyfriend throws your property out the third-story window onto the lawn, breaking your television. That too would be considered conversion, as he has destroyed your property. As an intentional tort, he would be required to destroy the property or damage it beyond use. If he were to calmly place it on the front lawn and it were to be destroyed, that might be something else, such as negligence, but it would not be conversion since he didn't intend to deny you the use of your property. Trespass. There are two forms of trespass: trespass to chattels and trespass to land. Trespass is using another person's property for your own benefit. Trespass to chattels is taking someone's personal, sometimes called chattel, property for your own benefit. Perhaps you borrow someone's tools for a weekend without their permission. This is not conversion because you are not seeking to take someone's property permanently or deny them the use of it forever. Trespass to land is simply disregarding their land, called real property, right for your own benefit, such as cutting across someone's property without the permission. Interference with contract or economic expectations. If two individuals have a valid contract and a third party comes in and induces one of them to breach the contract, they can be sued for interference with contract. Let's say that I'm employed at a business owned by vocal Republicans. You don't like the fact that I work there and tell the owners that I voted for a Democrat during the last presidential election to get me fired. Another example could be a restaurant with outdoor dining. If protesters were to come out and harass the diners, preventing people from coming to your restaurant, you may be able to argue this for that tort. Intentional infliction of emotional distress. Emotional distress, much like pain and suffering, is something that everyone loves to sue for. An emotional distress suit is often a difficult lawsuit to win. There are several things you must prove in order to recover for intentional infliction of emotional distress. Like with all intentional torts, you must prove that the defendant acted intentionally. Next, you must show that the plaintiff suffered emotional distress and that the bad act caused the emotional distress. Finally, you must show that the conduct was extreme or outrageous. When suing for intentional infliction of emotional distress, it's important to note that last factor. Something being extreme or outrageous is not the same thing as being rude or mean. It must go beyond the realm of what any decent human being might consider appropriate. One example of this might be modern cyberbullying cases that lead to self-harm. Some mean Twitter posts tagging the plaintiff is not sufficient. We would have to be talking about extreme behaviors, often over a prolonged period, designed with the intent to cause this emotional distress. Perhaps the plaintiff has recruited people to aid them in their attacks, or made fake calls leading someone to believe their parents have died. If behaviors like this were to cause some type of damage, such as a person having a mental breakdown, becoming bulimic, begin cutting, become an agoraphobe, or attempting suicide, a case might be present for intentional infliction of emotional distress. Defenses. There are a few defenses to intentional tort lawsuits. The first and easiest is that the act by the plaintiff wasn't intentional or made with reckless disregard for the danger they might cause. If I post a job online with a high salary and it causes an employee to quit their job to work for me, I have not committed the tort of interference with contract. I did not seek to get a specific person to quit their job. In other cases where there's an injury, it is possible that there might be a negligence lawsuit, but without intent, there's not an intentional tort. Another major defense is consent. Two people get into a fist fight outside of a club late one night at the end of a drunken argument. If the two people agreed to fight, then they have consented to the contact. Note that this does not mean that there was not a criminal act, depending on your state laws. It simply means that the parties cannot successfully sue each other if they consented to the fight. Defamation. Defamation is another intentional tort. Defamation is making a false statement that damages another person's reputation. Defamation can come in two forms, libel or slander. Libel is written defamation, and slander is spoken defamation. Regardless of whether it is libel or slander, the following 5 elements of defamation must be present. A statement must be published. Publication of a statement doesn't necessarily mean that you need to go off to a printer and have the statement memorialized permanently. Publication in this sense simply means that the statement must be cast out to the world. If you're making false statements in your head or simply lying into the wind, then you have not met this element. Publication can literally mean published, or publication can simply be speaking your words for the world to hear. The statement must be made to a third party. If I make a false statement about you, to you, then that is not defamation. I cannot damage your reputation to you because you already know that the statement is false. If I lie about you, to you, you can simply say, "Nuh-uh," shake your head and move on with your life. The statement must be made about another person. Defamation is an intentional tort. As with the previously mentioned defenses to intentional torts, if you consent to the act, then you cannot sue for it. So you cannot defame yourself. There are times people do occasionally make false statements about themselves. We all know someone who has done so, though most of the time they're doing it for some attention, to start drama, or some other personal gain. The statement must be false. This is the most important element of defamation. If I say something negative about you that is true, well, you cannot accuse me of damaging your reputation. You damaged your own reputation by doing the bad act. Many threats to sue someone for defamation come from people who are upset that someone is spilling tea about something they actually did. Take no heed of such threats. These threats are empty and designed to scare people into not spreading the negative statements. But if the statement is true, so long as you came across the information in a non-tortious or non-criminal way, then you are safe from a defamation lawsuit. The statement has caused the plaintiff damage. Not all false statements will cause the plaintiff injury. Sometimes the statement, by some twist of fate, improves the plaintiff's standing. This happens frequently with celebrities that have fallen out of the spotlight. A little bit of juicy gossip and suddenly people are talking about them again. Sometimes the statement meets all the other elements of defamation, but is so minor that no one cares. The point of the court system is to make a person whole. That is, to put them back at the position they were prior to whatever harm they suffered. If you've suffered no harm, then there's nothing to sue over. Defamation per se. Sometimes damages in a defamation lawsuit can be difficult to prove. The more damages that can be proven, the more a plaintiff can recover in a lawsuit. But even if damages cannot be proven, they will be presumed to exist in a few narrow circumstances. If you claim a person is a criminal, that they have an infectious disease, if you make claims about a person's sexual conduct, or if you defame a person's business, sometimes called disparagement, then the plaintiff needn't prove the damages element. They must still prove the other 4 elements, but damages are presumed. It doesn't take a large stretch of the imagination to see how these things could damage your reputation. Defenses to defamation. There are several unique defenses to a defamation lawsuit in addition to the other intentional tort defenses. Remember, if the statement is true, it isn't defamation. If the statement is an opinion, that too is not defamation. If you were to read this book and tell everyone that I'm terrible at writing and a bad lawyer, that's your opinion and not defamation. If you were to tell people that I'm unqualified to write this book because I am not a bar-admitted attorney, that would be defamation because that is alleging a matter of fact that is not true. There are some situations where you can meet all the elements of defamation and still not be held liable. State laws vary on this, but there are some circumstances where you have an absolute or qualified privilege allowing you to make the defamatory statement. Examples of this are statements made between spouses, statements made by a qualifying government official, isn't that convenient, lies made in self-defense from physical harm, or statements made in court. There are a lot of nuances here, so you'll want to review your local laws to include case law. Statements made by government officials, especially during debates, are there to ensure lively public debate. Also, just because you cannot be sued for defamation for statements made while giving testimony on an oath does not mean that you'll be free from criminal perjury charges. Making false statements is rarely a good idea. Lastly, it's worth keeping in mind that the intentional aspect of defamation is the intent to publish the statement. If you aren't the originator of the false statement, but you repeat it, you might still be held liable for defamation. This includes if you didn't know the statement was false, but you had reckless disregard for its falsity. In other words, you should have known it was false, or could have found it out if you'd made a small effort. Further, a simple retraction of the statement is not enough to protect you from the lawsuit. If the elements of defamation are met, then you are responsible for defamation, even if you correct yourself later. Now, correcting yourself might lower the damages the plaintiff suffers, so it's still a good practice, aside from the unethical aspect of making false statements about others. False light. False light is like a form of implied defamation. The defendant hasn't flatly published a false statement. Rather, they've made misleading statements which they intend would cause a third party to draw their own defamatory conclusion. If a newspaper were to run a provocative story on its front page with your picture under it, people might be led to believe you were the person the story was about, even if you were on the cover for a different purpose entirely. Torts of privacy. There are many more torts than previously mentioned. We're going to close intentional torts with a few additional intentional torts that involve a person's privacy. The first is appropriating a person's identity. If a person uses your likeness to endorse a product without your permission, or pretend to be you and it causes you some harm, you can sue for appropriation. Disclosing private facts or intruding on someone's privacy are also intentional torts that you can recover for. Note that disclosing private facts might cause a person damage, but that isn't defamation because the statement is true. There are circumstances that telling the truth about someone is still an intentional tort, though, just not defamation. When it comes to intruding on another's privacy or disclosing private facts, there's a balance of interest test the court must consider. What they're balancing is the rights of the plaintiff against the public interest in that knowledge. The more public a person is, or the greater the public interest, the lower the privacy protection a person is going to have. The privacy protection that the president has is going to be lower than the privacy protection of your average citizen because there's a public value in knowing things about those we elect. Some of the activities of paparazzi towards celebrities are not actionable, whereas had they invaded your privacy in the same way, it might well have been. Negligence. Now, we've talked about intentional torts. These require that the plaintiff either intended to do the bad act or they acted in reckless disregard to the likely damage their action would cause. However, the most common torts are unintentional torts, commonly referred to as negligence. Under the tort of negligence, a defendant has failed to act with reasonable care, and the result of that has caused the plaintiff some harm. The word negligent is thrown around a lot, but in the law it has a very specific meaning. For a person to recover when they sue for negligence, the following must be met. A duty between the parties must be established. That duty must be breached. The breach of the duty must be the actual cause of the damage. The breach of the duty must be the proximate cause of the damage. And there must in fact be damage. Every time you consider negligence, from now until the day you die, you should ask yourself if all 5 elements are present. Duty, breach, actual cause, proximate cause, and damages. We'll address each element in turn. Duty. For a defendant to be liable for negligence, you must first show that the defendant owed some sort of duty to the plaintiff. That duty changes all the time depending on what the parties are doing. In most cases, the duty is to use reasonable care when engaged in whatever act they're doing. If I have friends over for dinner, I have a duty to wash my hands before I handle their food. My duty to wash my hands is only to the people I'm cooking for. I have no duty to wash my hands to people I'm not cooking for. I have a duty to use clean dishes and to cook the food safely. If I'm driving a car, I have a duty to the people on the road around me to be sober, attentive to the road, and to have a properly maintained car. I don't owe a duty to people in other cities to drive safely, only to those around me. In most cases, my duty is to use reasonable care. I must do what a reasonable person in my position would do. Unfortunately, we don't exactly know what a reasonable person would do, for there's no such person we can call up and ask. We determine what a reasonable person would do by leaving that question to a jury or reviewing established case law. In some narrow cases, the standard isn't what a reasonable person would do, but rather what a reasonable professional would do. A doctor driving on the road must do what a reasonable person would do. A doctor operating on a patient must do what a reasonable doctor would do. A reasonable person is far too low a standard because no one would put their surgery in the hands of an untrained person on the street. That's a recipe for disaster. We have something called the attractive nuisance doctrine, which relates to the element of duty. Under the attractive nuisance doctrine, the courts have held that if you have something dangerous that might attract people, especially children, then the owner of that item has a duty to use reasonable care to keep people out and safe. This comes up frequently with things like children in swimming pools. Many children drown each year in swimming pools. If you have a pool in your backyard, then you need to use reasonable care to keep people out. If they trespass onto your land and drown, you might still be held liable. The key here, as in so much of law, is the term reasonable care. If you put a sign out that says, private property, no trespassing, that might be sufficient for an adult. However, it's unlikely to be reasonable to keep young children out. You would need a fence. That is why you often see portable fencing placed around construction sites. It is that company avoiding being held responsible for anyone coming onto the site and injuring themselves. Breach of duty. Once the plaintiff has established that they are owed a duty by the defendant, they need to show that the defendant breached their duty. They must show by a preponderance of the evidence that the breach in fact occurred. That burden is on the plaintiff. The person who came over and got sick during my meal must show that I didn't wash my hands prior to cooking. The person who was injured in the car accident must show that the defendant was drunk behind the wheel or that they were texting while driving. The person suing for medical malpractice must show that the doctor did something no other reasonable doctor would have done during the surgery. Actual cause. We all owe countless duties to others throughout the day. Quite often we breach those duties to each other. Almost everyone has texted while driving, but nothing happened. Someone may come to work sick, putting their coworkers at risk, but no one becomes ill. For there to be a successful negligence lawsuit, the plaintiff must show that the breach of the duty was the actual cause of the injury that they suffered. This is sometimes referred to as but-for cause. But for the defendant breaching their duty, would the plaintiff have been injured? In other words, is the breach of the duty the reason for the injury? If a person comes over for dinner and I don't wash my hands, I've breached a duty to them. If that person then leaves and gets into a car crash, that car crash didn't happen because I didn't wash my hands. It happened for some other reason. Despite my breach of duty toward them, they cannot successfully sue me for negligence. If a doctor prescribes me the wrong medicine and I step on my kid's Legos and fall down the stairs, breaking my leg, I cannot sue for medical malpractice. The bad medicine isn't why I fell. Proximate cause. In addition to the breach of duty being the actual cause of the injury, it must also be the proximate cause. This means that it must be foreseeable to a reasonable person that breaching the duty might cause this injury. The whole point of negligence lawsuits is to get us to stop for a moment, consider our duties to each other, and to act in a reasonable fashion to avoid the possible harm we might cause. If no reasonable person would be able to foresee the possible damage, then the court will not hold them responsible. This element of proximate cause is best illustrated in a case called Palsgraf v. Long Island Railroad, 248 New York 339, 1928. It is foreseeable that driving drunk might cause an accident. We know that it impairs a person's ability to drive. We know that not washing our hands prior to cooking can make someone sick. Take a scenario where I do not wash my hands prior to making dinner for some friends. Everyone comes over and has a great meal. A few hours later, after everyone goes home, a friend calls up to thank me for the meal. Somewhere in the conversation, I apologize and mention that it had slipped my mind and I had forgot to wash my hands before cooking. This causes the friend to panic that they might get sick, and they, foolishly, drink a fifth of bourbon because they think alcohol will kill any diseases they might have. The friend becomes drunk, trips and falls down the stairs, breaking his leg. In this case, I am the actual cause of his injury. Had I not washed my hands, he wouldn't have drank the alcohol. Had he not drank the alcohol, he wouldn't have gotten drunk. Had he not gotten drunk, he wouldn't have fallen down the stairs. Had he not fallen down the stairs, he wouldn't have broken his leg. There is a connection from the injury to the breach of my duty to wash my hands. But it is not foreseeable that not washing your hands before you handle food might lead to a person breaking their leg. There's no proximate cause and therefore no valid negligence lawsuit. Damages. The last element of a successful negligence lawsuit is damages. The entire purpose of suing a person in court is to put yourself in the position you would have been had the bad thing not happened to you. Let us return to our hand washing example. I have a duty to anyone I cook for to wash my hands prior to touching their food. I did not do it, so I have breached my duty. Because of it, you become ill. Not washing my hands is the reason you got sick, so there is actual cause. It is foreseeable that not washing my hands might result in someone getting ill, so there's proximate cause. Now, if you felt ill, but you never had to go to the hospital or miss any work or need medicine from the store, then you have not been damaged. I haven't put you through any real hardship. If you haven't been damaged, you cannot be returned to your pre-damaged position. There are no damages, and therefore there is no viable negligence lawsuit. Negligence per se. You now know the 5 elements of a good negligence lawsuit. However, there is a way to skip over all of this and have a person automatically be held liable for negligence without going through the effort of proving all 5 elements. Under negligence per se, if a defendant violates a law that is specifically designed to prevent the injury the plaintiff suffered, then they can be held liable for negligence without having to do a complete negligence analysis. Drunk driving and texting while driving both fall under negligence per se. These laws are in place to prevent car accidents. If the plaintiff is hit by a car driven by a drunk driver, then they could sue for negligence per se. Perhaps a restaurant violates food storage laws and the plaintiff gets food poisoning. Again, this could fall under negligence per se. Res ipsa loquitur. When a person sues another for negligence, the burden of proving their case is on the plaintiff. The plaintiff is making the accusation, so it becomes their job to prove their accusations. This is like criminal law, where a defendant is presumed innocent until proven guilty. The defendant is starting from a position of not being liable. However, there is an area of law that flips the burden of proof from the plaintiff to the defendant. Res ipsa loquitur is a Latin term for the thing speaks for itself. Under this doctrine, the burden of proof has now been shifted. The default position is that, all else being equal, the defendant is presumed to be liable for the injury, and the burden is now on them to prove that they were not negligent. This doctrine must be applied to the case before trial as a pretrial motion. You would be required to draft an argument and have the judge agree with this doctrine. It is not automatically applied. For res ipsa loquitur to apply, the plaintiff must show that the defendant was the only person in control of the instrument or action that caused the injury, and that there is no reasonable explanation showing that this injury could have occurred outside of a negligent act. We see this a lot in medical malpractice cases. Occasionally, the news will run an outrageous story of some sort of injury where a person going into a hospital for a simple surgery ends up with an amputated limb or comes home to find that they were sewn back up with a pair of forceps still inside of them. In these cases, the only way the injury could possibly occur is if somebody really screwed up badly. If you're walking your dog on the street and are suddenly hit by a tire flying down the road, the only way that could happen would be if someone really messed up somewhere. There's no reasonable explanation for this type of injury. Note that res ipsa loquitur is not negligence per se. It does not prove liability. It simply shifts the burden from the plaintiff who makes the accusation, and now the defendant must prove that she was not negligent. Defenses to negligence. Now that we've talked about the many ways a person might successfully file a negligence lawsuit, let's step back and see how the defendant might avoid liability. We're going to cover a few areas, but as always, you need to consider any nuances of law in your local jurisdiction. First and foremost, the best way to defend oneself from a negligence lawsuit is to attack the elements of negligence itself. A defendant needs only to show that the plaintiff did not meet their burden of proof for one of the 5 elements to prevail. However, if they cannot, they can have the court consider the following. Assumption of risk. If a plaintiff has assumed or accepted the risks associated with an activity, they cannot win a negligence lawsuit. They're recognizing that the activity they're engaged in is inherently risky. This is the sort of thing you often see when you sign a waiver releasing a company or some other person of liability. What's important to note here under the assumption of risk doctrine is that you're only releasing the other side from the risks that are normally associated with that activity. Even if you sign a waiver, you can still sue if the other side is acting negligently in a way that causes an unexpected injury. Most of the time, the courts will only enforce a waiver if it explicitly lays out the risks. A blanket waiver that simply says that you won't sue no matter the injury is unlikely to hold up. If you go skydiving, you're assuming the risk of a parachute tearing. You're not assuming the risk that they allowed a drunken, blind, homeless guy off the street to pack your parachute for you, unless they warn you beforehand that that's who they're using, instead of a professional to pack your chute. Good Samaritan laws. Most states have laws in place that will protect people who render aid to others if they do so imperfectly. Many of these laws came into existence specifically to prevent those scenarios where a person is rescued by another, suffers an injury in the process, and sues their rescuer. State laws vary, but most Good Samaritan laws protect a defendant who acts, sometimes even somewhat negligently, while aiding another. It will not protect from recklessness or grossly negligent behavior, where a person does something that they know is dangerous. A person who is perhaps a little too forceful while giving CPR and breaks a person's ribs would be protected. A person who ties a tourniquet around the neck of a person with a leg injury would not. Contributory and comparative negligence. It is common in many negligence cases for both parties to share in the responsibility for the injury. If you think back to the pleading section in Chapter 1, I talked about the defendant filing a counterclaim and suing the plaintiff right back. In a simple car accident, the plaintiff might allege that the accident occurred because the defendant was speeding. The defendant, in turn, might sue the plaintiff right back in the counterclaim, or simply defend themselves in the answer by saying that the accident happened, but not due to their speeding, but rather because the plaintiff was texting while driving. State laws vary, but in contributory negligence states, if the plaintiff shares liability in any capacity, then they lose their case outright and recover nothing. State contributory negligence statutes occasionally modify the percentage that triggers this effect. Most states operate under a comparative negligence standard. In these states, the plaintiff's award is reduced by the amount that they share in the negligence. Let's say that the plaintiff is suing for a car accident. They've suffered a total of $100,000 in damages. They allege that the defendant was texting while driving and not being attentive to the road. At trial, the jury agrees, but decides that the plaintiff was also 30% liable for the accident because he was speeding. In this case, the plaintiff's award is reduced by 30%, and he only recovers $70,000. This is for a comparative negligence state. In a contributory negligence state, the plaintiff would recover nothing. Strict liability. Intentional torts require intent to engage in the bad act or to recklessly disregard a high risk. Negligence requires that a person not use reasonable care in their action. Strict liability ignores all of that and attaches liability regardless of intent or how cautious and careful a defendant is. Under strict liability, a person is liable regardless of fault simply because they're assuming the responsibility of someone getting injured when they engage in any especially dangerous activity. What falls under strict liability is frequently set out in statutes and case law, but some common ones are working with explosives or owning wild animals. Under negligence theory, a person would be free from liability so long as they were careful in the ownership and use of these activities. Under strict liability law, no one cares even if you go above and beyond all reasonable bounds of caution. If a person is hurt, you're responsible. Full stop. Product liability. Product liability is like a hybrid of strict liability and negligence. Under product liability tort law, if a person is injured by a product, then anyone in the chain of distribution, from the designer, the manufacturer, the supplier, the distributor, all the way down to the retail store it was purchased from, may be held liable for damages. The primary exception to this is casual sales, things like yard sales or things purchased on Facebook Marketplace. There are 4 categories that trigger product liability lawsuits: defect in manufacture, defect in design, defect in packaging, and a failure to warn. Defect in manufacture. A defect in manufacture is some sort of flaw in an individual product that results in injury. A defect in manufacture is often the result of shoddy workmanship in a product or a failure to catch a defective product in the quality control phases of manufacture before it leaves the factory. If a child were to choke on a doll's head that popped off too easily, or a weld breaks on a new car frame, a person could allege a defect in manufacture. In each of these cases, the individual product was defective. Most of the identical products work just fine. Defect in design. With the defect in design, all products of this type are defective. Whoever created the product created it in such a way that there's a high risk of injury. Consider the danger behind a table saw. Having a table with an exposed blade is a dangerously designed product. To protect themselves, company remedied the defect in design by attaching a blade guard. One of the most famous examples of a defect in design is the lawn dart. Lawn darts were large, heavy metal darts in the 70s and 80s that you threw into a ring, kind of like how people play cornhole today. Many people were injured, and some died because the darts were heavy enough to pierce skulls. The courts found that these toys were inherently dangerous, so product liability attached. Today, lawn darts are almost impossible to find because manufacturers decided the resultant lawsuits weren't worth the money made on their sales. They're also illegal because some dorks with no chill at the Consumer Product Safety Commission said so. See CFR Section 1306. My guess is that no one invited them to have a beer at the park. How is it possible for an unelected group of people to pass law? Go back to Chapter 1 and review administrative agencies. Defect in packaging. Products must be packaged safely. Let's say you purchase a set of knives, but the packaging is thin plastic, allowing the knives to pierce the packaging and cut you. Perhaps there's a leak in a bag of dog food and a person becomes ill from the bacteria growing on the food inside. This would be a defect in packaging. Childproof caps are put onto medication or other dangerous substances like drain cleaners. Potentially dangerous products must be packaged in a safe way. A manufacturer must be cautious and consider how a product is going to be used and who is going to use that product. You want to ensure that it is not used by someone that shouldn't use it. You want to ensure that things are packaged safely. But if you package things too safely, then this could also activate a defect in packaging product liability tort. An elderly person needs medication quickly. If the cap is too difficult to get open, that too would be a defect in packaging. Failure to warn. Manufacturers are expected to warn people of the dangers associated with the product. If a person is injured, they can sue, alleging that they were unaware of the risks associated with using the product. Warnings must be made in a way that addresses the reasonable, normal risks associated with the product. Further, they must be presented in a way that is readily understood by the user. Like defects in packaging, this requires some degree of forethought by the product designer. They need to consider how both the product might be used and how it might be misused. By not providing a warning, there's a failure to warn. However, by providing too many warnings, there may also be a failure to warn. We're all familiar with opening a product and finding a giant booklet in 12 languages and 8-point font full of every conceivable danger with something as simple as a hairdryer. No one reads it. Now there's a failure to warn. Warnings must be placed in places they'll be seen, noticed, read, and followed. Defenses to product liability torts. If you underpackage something, you can be sued. If you overpackage something, you can be sued. If you underwarn, you can be sued. If you overwarn, you can be sued. If you're the retailer and have no idea that you even have a dangerous product, you can also be held liable. If you feel somewhat helpless right now, do not fret. All is not lost. there are still several defenses to a product liability tort. Generally known dangers. The generally known danger defense is a solid affirmative defense you can plead if you're being accused of a failure to warn. You don't need to warn someone about everything. As mentioned, too many warnings may cause a person to ignore your other important warnings. You do not need to warn someone about something everyone should already know. If you're selling a gun, you needn't warn people to not stand in front of the shooty end. If you're selling a hairdryer, you don't have to tell people not to dry their hair while taking a shower. People should know this already. Abnormal misuse of a product. If a product is used in a way it was not designed, and that person is injured, they cannot successfully sue for their injury. However, this is like the failure to warn category. The manufacturer or designer must consider all the ways that a person might misuse their product, and both warn and design around that misuse accordingly. In a previous example under defect in design, I mentioned table saws. The table saw has a defect in design in that there's an exposed blade that can take off fingers or kick wood back into the face of the user. One way to remedy this was to put a plastic guard over the blade. The problem remained that a cheaply made blade guard can get in the way of a clean cut, so many users would remove the blade guard and proceed to injure themselves. Even though the table saw was misused, used with the guard removed, the defendants could still be liable for injuries. Now, take this same table saw and have it used by pushing it over stationary wood, like a wall, instead of having wood pushed over it in the traditional way. If someone were to be injured in this absurd use of the tool, the misuse would be considered abnormal and the plaintiff will recover nothing. Whether the use is abnormal or not is a question of fact, though. That leaves the matter up to the jury or a judge if it's a bench trial. Supervening events. If the product is modified in some way after leaving the manufacturer, then that person cannot be held liable. For a product liability case, anyone in the chain of distribution can be held liable. A car leaves a manufacturing plant. The car dealer receives the car and adds or removes some parts. If the car ends up causing injury, then the manufacturer is clear of liability, for she has offered the dealer a different product than what the dealer sold the customer. Government contractor defense. Government contractors are often protected by statute from product liability cases. For this protection, they must provide a product that has met certain government standards. The government frequently wishes to purchase from the lowest bidder. So, do not be impressed when you hear that something is military grade. That generally means low quality. One of the ways to ensure low bids is to protect the manufacturer from tort liability. Assumption of risk. As with negligence, if a person uses a product knowing the risks associated with that product, they cannot win a lawsuit if they're injured in a way that's normally associated with the risks inherent in that product. Like with the assumption of risk defense in negligence, this is not a blanket protection that removes all liability. It is only a relief for liability of the known, normally associated risks with that product. Statutes of repose. A statute of repose is like a statute of limitations. A statute of limitations in civil cases requires that a person act within a specific time after discovering their cause of action, what they want to sue for. A statute of repose will begin to run before a person is injured. If you were to somehow come across lawn darts in some faraway, forgotten corner of your local Walmart and were to become injured, you would not be able to recover for your injuries because lawn darts were discontinued decades before your injury. Damages in tort cases. One of the most difficult and awkward things the courts must do is calculate damages in a tort case. When a person sues, their goal is to have the courts return them to their pre-injured state. It is not to turn a profit. Sometimes this is easy. A car can be taken to a mechanic and repaired. A destroyed yard can be resodded. A house can be rebuilt. But other times it's not so easy when the main thing the courts can use to make you whole again is money. How do courts determine how much money returns a person to normal when they've lost a limb, their eyesight, their spouse, a priceless heirloom, or even their pet gerbil? The most common types of damages are compensatory damages. Compensatory damages are those actual damages suffered by the plaintiff. In a car accident, they might include the mechanic's bill for repairs to the car or the doctor's bill for repairs to you. If your injuries caused you to miss work, you might be able to recover the wages you lost. In the recent Johnny Depp versus Amber Heard defamation case, The jury was able to determine a dollar amount of the reputational damage Mr. Depp suffered, evidenced by lost revenue from movies he was not cast in. There are many forms of damages a person might suffer, and if you can demonstrate it to the court, you can seek compensation for it. Your imagination and your ability to get the court to agree with you are your limits. But remember, you are seeking to be made whole, so this must be actual damages that you've suffered. Under the eggshell skull rule, the courts have decided that if the defendant is in fact liable for tort damages, that this includes even the unforeseeable damages of that person's action. Consider this in light of proximate cause. Proximate cause means you are responsible if it is foreseeable that your breach of duty might result in damages. The eggshell skull rule sounds the same, but it does not contradict it. Further, it does not only apply to negligence. It simply means that if damages are foreseeable, then the defendant is responsible for the extent of those damages, even if those damages are unforeseeable. If a person gets into a small fender bender in a parking lot, and the result is that the plaintiff suffers severe injuries, such as if they were to have a brittle eggshell skull, then the defendant would be held responsible for all damages, even though it's highly unlikely or unusual for a person to be injured so badly. The next form of damages are punitive damages. Punitive damages are designed to punish the bad actor for their behavior. With punitive damages, it is possible for the plaintiff to recover more money than their injuries justify. Punitive damages are generally not awarded for negligence unless the negligence is severe. In most cases, punitive damages are only awarded for intentional torts because they're seeking to discourage this bad behavior. The famous McDonald's hot coffee case is an example of punitive damages in action. McDonald's had discovered if they were to make their coffee dangerously hot, well beyond what a person could drink, that they could get an extra cup of coffee out of the same amount of beans. The court sought to punish McDonald's for extreme negligence and their reckless disregard for the safety of their customers by awarding over $2 million in punitive damages, 2 days' worth of McDonald's coffee profits. This number was later partially reduced by the judge. Most state laws place caps on punitive damages. The last type of damages are nominal damages. Nominal damages, like in contract law, are damages in name only. Nominal damages are necessary when the plaintiff has not actually suffered actual damage, but a winner needs to be decided for an award of attorney's fees or an application of punitive damages. If a person were to commit the intentional tort of trespass to land, but they did not actually cause damage to the land, the court might award $1 in nominal damages, but then apply attorney's fees and punitive damages to punish the defendant for their bad acts.